In this video, I will be discussing confessions with you. And I know when I mention the word confessions, the first thing that people think about is Miranda warnings. However, even if the agent provides Miranda warnings to the defendant, that does not mean that that confession can come into court at trial. The confessions must still be voluntary and done without coercion. So let's go ahead and discuss this particular case that deals with involuntary confessions. Today we'll be discussing United States versus Shane Young, which is a 10th Circuit case from last year, and it deals with involuntary confessions. Now, I know I often don't provide the full site here on the whiteboard, but believe me, if you go down and look below at the information section under this video, if you're watching it on youtube.com, you will see that I provide the full site. I give you more information about the case, and I even give you the link to click on to read the full opinion from the court. So let's go ahead and discuss Shane Young. We have Mr. Shane Young who flees from the officers in his vehicle. Eventually he gets pulled over. He throws away 4 grams of meth, which is later found in the area where he was arrested, inside a little container that held his headphones. That's why I drew little headphones here. 4 grams. Now, he was arrested, interviewed, but later that day, police returned to the same location and they found a backpack. Inside the backpack, there was 93 grams of methamphetamine. Shane Young was rearrested. He was then brought in and interviewed by the agents, interrogated. Now, something to remember, he was provided Miranda warnings, so Miranda is not at issue, so you can forget about it. It was a proper warning, so let's move on. Let's discuss something that we should always focus about, which is whether the confession is voluntary. The Constitution tells us that if the confession is involuntary, it must be thrown out at trial. What does it mean to be voluntary? Well, first we have to look at coercion, whether there's any physical or psychological coercion by the agents. Is it made freely and voluntarily and without threats, compulsion, or inducement? How do we do that? First, we look at the agent's conduct. What did the agent do during the interview? And then we can focus on the defendant. Does he have any mental issues that make it difficult for him to understand what's going on? So here's what happened in this case. Mr. Shane Young gets interviewed, and the agent tells him that if he confesses to the second finding, the 93 grams of methamphetamine, because here's what happens. Shane Young actually confesses to the first 4 grams. But he says that he knows nothing about the backpack. It's not his backpack. The agent promises leniency to Mr. Young. He says that Mr. Young is looking at 5 to 10 years in prison, depending on his cooperation. And that if he provides truthful information about the backpack, he can buy down the time in federal prison. He says that every time he answers the questions truthfully, it ticks time off that record. That's the way it works. So he explains to Mr. Young that every time he provides a truthful information, it ticks down the time off of his sentence. Now, he says that from this point on, the agent is on Mr. Young's side, which I know we know it's not true. He's trying to get a confession out of Mr. Young. He's not on Mr. Young's side. And finally, the agent several times tell Mr. Young that he has met with the judge looked at the defendant's record, and that if he provides truthful information, he will look at less time in prison. Now, during the hearing, the agent clarified to the court that that's not what he meant, even though he said it. What he meant is that he met with a prosecutor on the case, the United States attorney. Well, I wrote here, That's very different. If the agent meets with a judge versus meeting with a prosecutor. Of course, the agents meet with prosecutors every day. That's how we initiate criminal cases in federal court. But it is rare, if not ever, that I see an agent actually meeting with a judge to discuss a case. That just doesn't happen. And the court says, the 10th Circuit, that we should be looking at this from the standpoint of the defendant. What did the defendant think? Well, the defendant thought that this agent has some kind of access to the judiciary and that they're buddies together. This particular agent and the judge, they talk to each other all the time. And by the way, in terms of the law, the agent was also wrong. If Mr. Young was prosecuted for 4 grams of methamphetamine, he would be looking at a maximum of 20 years in prison. There is no mandatory minimum on that amount of drugs. And even more, he could have been charged with simple possession, and in that case, he would be looking at 1, 2, or 3 years in prison. Now, because he confessed eventually to 97 grams, that actually carries a mandatory minimum of 5 years and up to 40 years in prison. So it's a huge jump. So the point is, the agent was wrong. Mr. Young was not looking at 5 to 10 years in prison, depending on cooperation. This is what he was looking at. Now, the 10th Circuit says that agents are not required to know the law. They don't have to know exactly how much time you're looking at. And in fact, it's actually a pretty difficult task. I have hundreds of videos on this channel discussing sentencing guidelines. They're not as easy as they seem. And so we don't require agents to know them. But we also ask that the agents don't lie to the person about the guidelines and how much time they're looking at. Now, the 10th Circuit says because there was this false promise of leniency, the agents did not know the law and they misstated it. And finally, that they provided this false hope that there's access to judiciary that this particular agent had. Because of those 3 things, this confession was in fact involuntary and it's made coercively. Now, of course, we can now look at the second issue, whether there's any mental conditions that the defendant has that makes this particular confession also involuntary under that second rubric, but we don't have to. There is no issues with mental state here, so the court said that's all we have to look at is the first item, the actions of the police. And because of those 3 items, the court says this confession should have been thrown out of court and never went to trial. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. Oh, and something I forgot to mention. We're now restocked on all sizes of my famous Do Not Arrest This Person t-shirt, from size small all the way to extra, extra large. And if you have a badass baby, we even have these onesies. Aren't they cool? It says, do not arrest this person. If you're interested in purchasing one, look at the directions that are about to follow in this video or go to lawstache.com/merch. Thanks for watching.